Hi, folks. Steve Fernandez back here again. Just to let you know a little update on my court case that came up for school compulsory attendance violations for myself, parent contributing to non-attendance, and my daughter Stephanie for failure to attend school. And it's funny because I go into the magistrate's office, and the first thing was that we went ahead and did a not guilty plea. And, of course, we were told then that we would have to wait till November 7th and see the prosecutor. Well, that didn't sit well with me. Of course, I was a little catty to the court clerk when she basically spouted off attitude towards me. So I spouted attitude right back to her. But that's neither here nor there. So I'm driving with my daughter, and I go ahead and decide to turn the car around, and I told my daughter, we're going to go ahead and go change our pleas. So we pleaded no contest so we could see the judge. Because, frankly, the prosecutor is not a judge. He cannot legally preside over any legal matters when it comes to judicial judicial matters in general, because he is working for the state as counsel, not as a interpreter of the law. So we went ahead and we saw the judge. We sat there in the courtroom being bored, and they got everything started. And, of course, our illustrious district attendance officer came in, and basically gave us his presence. I'm for a loss of words here, so just bear with me. But anyways, we go ahead, we start the cases, and it's going rather a little slow. I just wanted to get out of there, and my daughter's about falling asleep. So they finally called us up, and they asked my daughter, you pled no contest to the charges of failure to attend school. Is this your signature? Of course, she was very respectful. She said yes. And, of course, our district rep did not have the proper paperwork on the case in which they filed the complaint. So, being the good Samaritan I am, I provided the court with the documents and the paperwork that the district had given me on attendance. And the judge looks at it, and the attendance officer looks at it too. And so they are going to pretty much try to put her on a 60-day plan for attendance. And I asked for a motion to dismiss. This floors the judge, and it floors the district representative. And he said he wanted to know on what grounds. And I told him, well, it was because of this little paper right here. I'll go ahead and kind of put this up so y'all can kind of see it. See if I can get that looking right. This little paper right here, which is the Texas Attorney General's opinion. This is from Greg Abbott. And it's opinion number GA0574. Now remember that. Texas Attorney General's opinion GA0574. And it's regarding school district responsibility under Section 25.0951, subsection A of the Texas Education Code. And I told them that the district failed their responsibility to properly file a complaint on my children in the allotted time, which states here in the subsection that if a student fails to attend school without excuse on 10 or more days or parts days within a 6-month period in the same school year, a school district shall, within 10 school days of the student's 10th absence, file a complaint against the student or student's parents or both in a county justice or municipal court for an offense under Section 25.093, which was mine, and or 25.094, which was my daughter's, as appropriate, refer a student to juvenile court in the county with a population less than 100,000 for conduct of violations that violate Section 25.094. Now, here's the kicker. In the second part of this, in subsection B, it says a court shall dismiss a complaint or referral made by a school district under this section that is not made in compliance. Not made in compliance with this section. So, parents, if you get your district paperwork on attendance and you see the filing date, make sure to count every absence and find when the 10th absence was. This will make sure that they're in compliance, and I do mean compliance. They have to follow this. This is not something that is just, multiple choice. It's not something voluntary. This was written into the law of the Texas Education Code, which states that the school district has to file within 10 school days of the 10th absence. So, mind you, it was very, very enlightening because the judge, after reviewing in confusion my motion to dismiss and trying to tell me, well, they filed within 7 days of the last absence. I said, no, sir, they filed 10 days. They have to file within 10 days of the 10th absence. They filed a month after the 10th absence. So, after reviewing this document and reviewing the paperwork that I given to the judge, he told the district attendance officer, said, I'm afraid that Mr. Fernandez is right, that we have to go ahead and dismiss this case because there is no jurisdiction. So it's dismissed due to, lack of jurisdiction. So another victory for parents, another victory for myself against the school district that obviously thinks that, parents are unintelligent and cannot figure these things out. I'm living proof. So parents, if you need to get your children out of a sticky situation, again, remember this, Texas Attorney General's opinion, GA 0574. And trust me, the district representative, before I left, gave a chilling threat to every parent that was there that listened to me, stating that they were going to start going ahead and filing against children who have 3 or 4 unexcused absences within a 4-week period. And it doesn't affect me. It's not going to make parents hate me more. It's going to make them hate the school district even more. So, they just basically put their foot in their mouth and pretty much, cut their own throats. So, I'm grateful for doing this for my kids, and you parents out there, advocate for your children. Do not buy into the system. Do not buy into the district's lies. Do not buy into the court's interpretation of what Texas compulsory school attendance laws are. Find out for yourself. Y'all have a good day. I had a great day. I just wanted to share my good news with you.